Hello, everyone. Welcome back to the Carly P. Riley Show. If you are a longtime viewer of this program, you know certainly that I have spent a lot of time and that I continue to spend a lot of time focusing on diving into the FTX bankruptcy. And I know that most of the world has tuned out of this conversation. They've tuned out of the bankruptcy. But the reason I am still here is that I have realized and understood that there is a lot that is very anomalous about this bankruptcy. Bankruptcies are always strange. I had someone joke with me today that there's an expression, if you've seen one bankruptcy, you've seen one bankruptcy. As in, every bankruptcy is unique, and in some ways, every bankruptcy is a bit weird. But this bankruptcy is especially weird. And that's not coming from me. It's coming from lawyers and bankruptcy experts who have looked at this and said, this is so atypical even for a bankruptcy. And my concern is that embedded within that atypicalness, embedded within all the strangeness that is happening, there is a cover-up, there is criminality, there is behavior that is potentially further victimizing the folks who have already been victimized by this crime. And to me, I sat in court every day and came home and made podcast episodes every day about the trial of Sam Bankman-Fried and the original story in which these customers were victimized. And I want to see this story through, including the parts who are potentially being victimized again in this bankruptcy process and by a series of very wealthy and well-connected insiders. And I've said this before, but I actually think this story is potentially, depending on where things land, potentially even more important than the original Sam Bankman-Fried story, because it strikes me that wheelings and dealings by well-connected and therefore well-protected and very wealthy insiders, law firms, etc., is actually a more common way in which the system is rigged and people are screwed than the story of one billionaire, boy genius, effective altruist who misappropriated funds. And like that story is rarer than the insider dealing screwing over the little guy. So that is my interest in the story. And I always like to clarify that when I talk about this bankruptcy, because I want people to understand why it still matters when for so many people they have tuned out. Okay. So with all of this said, some of you may know that the folks running this bankruptcy, the folks who are these insiders who I think may potentially be re-victimizing some of the folks who have already been hurt in this whole saga, they have released a bankruptcy plan. This is a normal part of bankruptcy. And you will be unsurprised to hear, if again, you have followed this show, that within the bankruptcy plan that has recently been put forward by the debtors, the folks who are running the bankruptcy, there continue to be strange, anomalous things. Now, I talked about this bankruptcy plan a little bit in a video last week where I expressed frustration and concern and skepticism about the fact that the FTX exchange is not being restarted in any way, or even frankly being sold in any way. But I want to talk about these other pieces of this bankruptcy plan about which I have some skepticism. First and foremost, the folks who have been running this bankruptcy, namely John Ray III and Sullivan and Cromwell. John Ray III, who was essentially appointed by Sullivan and Cromwell to run this bankruptcy and who then in turn immediately hired Sullivan and Cromwell. John Ray III has been named as the plan administrator. So basically the person who, after and if this bankruptcy plan is confirmed, John Ray III will stay on to manage the wind down, to continue to run and manage the FTX bankruptcy and the exchange and whatever's left of it after this plan is confirmed. Now, this is very atypical. So first of all, most bankruptcies, of course, are not a result of fraud. There are plenty of companies that go out of business or that file for Chapter 11 bankruptcy, which typically is filed in order to try and restructure a company. There are plenty of people who file a Chapter 11 bankruptcy simply because it was mismanaged, but not in a fraudulent way, or because macro factors changed or whatever. Businesses go out of business, right? And so it is actually pretty common and that the team that managed a company before it went bankrupt stays on as the team that manages the company after it went bankrupt. This didn't happen in this particular case because, of course, the team that was managing the company pre-bankruptcy was accused and then convicted of fraud. Now, I've spoken, of course, before about the fact that Sullivan and Cromwell was one of the law firms for FTX US. So it is strange and a conflict of interest that they have been allowed to stay on to manage this bankruptcy process. But we are now talking about a second component of this, which is they are also now, and primarily John Ray III, are being spoken about as staying on to manage this plan even after the bankruptcy plan is confirmed. And that is a second level of weird to all of this. And I want to give you a specific example here, a very resonant example. So John Ray III, who has been running this FTX bankruptcy, he has often talked about, or he is often credited as being the CEO for Enron and like shepherding the Enron bankruptcy. I have even described things this way about John Ray III because it is sort of the prevailing sentiment and narrative around John Ray III and his background. But the truth is actually more complicated, and I've started to learn this more recently, which is that it was actually a gentleman named Stephen Cooper who ran Enron and who was the CEO of Enron immediately after its collapse and after it filed for Chapter 11 bankruptcy. So the work of restructuring Enron and that initial preliminary work that was done in the bankruptcy, what has been happening so far in the FTX bankruptcy by comparison, was done by a man named Stephen Cooper, not by John Ray III. John Ray III then came in and managed the wind down entity. It had a different name actually. John Ray III was the chairman of the Enron Creditors Recovery Corp, which was the entity that was left after the bankruptcy plan had been approved and the bankruptcy had sort of happened for Enron. And in that capacity, John Ray's responsibility was really selling off remaining assets, finalizing any litigation that was ongoing, but it was the wind down entity. Okay. Why do I give you all of those details? I mean, one, it's interesting because it does feel like John Ray III has perhaps misled lightly people as to what his role in the Enron situation was, arguably, or the press simply has gotten it wrong and run with it. In any case, that's somewhat interesting. But second of all, because John Ray III himself has been a part of a bankruptcy in which the normal checks and balances existed, which is to say there was one person who ran the initial restructuring, the initial piece of things, and then somebody else came in to run the wind down after the plan was confirmed. And usually, if there is going to be a wind down, if the company is not going to be restarted, what is typical is for there to be two different people in these roles. It provides checks and balances in the system. The second person who comes in can maybe look and just double check that everything that the first person did was correct, was done properly. They can follow up on things. Like, it makes sense to just have two different people in these various roles. But yet again, in this bankruptcy, things are being run differently. The current debtors, which are John Ray III and Sullivan and Cromwell, are asking that John Ray III stay in charge and continue to run the bankruptcy. Now, genuinely, there may be any number of reasons for this. I will say it also would fit a narrative in which the debtors have not run this bankruptcy properly, have not perhaps behaved in the most upstanding way, and therefore don't want somebody else coming in, mucking about, looking at what's been done so far and asking questions. Now, there's a person named Mr. Purple. That is their name on Twitter. Folks may or may not be familiar with this person. They put out a really good tweet listing a number of problems as they see it with this bankruptcy. And they, of course, also cited the governance challenges here, what I was just speaking about. They also cited the fact that John Ray III is staying on as the plan administrator, or is proposed to stay on as the plan administrator. And they also pointed out that the board that would oversee the plan administrator in this new post-bankruptcy plan world is the same board that is currently overseeing things. And so you therefore won't have any new oversight over what's happening in this very anomalous bankruptcy. Now, what Mr. Purple says here is that there should be a customer or a customer creditor representative on the board, which I totally agree with. Somebody who is clearly first and foremost and singularly an advocate for the creditors should be a part of having oversight of what's happening as part of the bankruptcy. And Mr. Purple also mentions that the UCC, which is the Unsecured Creditors Committee, it's another body that has the creditors' interest in mind, and the ad hoc committee, another committee within this, should be the ones to pick the plan administrator, as opposed to it being picked by the current debtors. The current debtors are picking themselves to be the plan administrator, and just hoping that everyone accepts that. Now, the second and final piece that I want to talk about when it comes to this plan, which I did not talk about when I spoke about it last week, that is, again, anomalous, though we're going to talk about the nuances here, has to do with the exculpations and releases that Sullivan and Cromwell are seeking, or that the debtors, I should say, are seeking as part of this plan. So to break this down just a little bit, something that creditors have long been concerned about is that if there was fraudulent behavior, complicit behavior by Sullivan and Cromwell in the work they did for FTX prior to the bankruptcy, so the work they did for FTX US before everything collapsed, that Sullivan and Cromwell will through their work now in this bankruptcy, basically managed to get themselves releases so that they cannot be held accountable for any of that complicity if it happened. There is even currently a lawsuit against Sullivan and Cromwell, accusing them of having aided and abetted the crimes that took place prior to the collapse, and looking to hold Sullivan and Cromwell account for those crimes. Now, I spoke about the issue of releases and exculpations with Jonathan Lipson, who is a law professor at Temple University. He specializes in corporate law and bankruptcy law. And what he said looking at this new plan is it's interesting because it actually appears that the debtors have narrowed the releases that they're granting to themselves, essentially, in this new plan, this new draft of the plan, I should say, as opposed to the earlier draft of the plan that they had put out. However, that is potentially more cynical. This is me saying this. This is potentially more cynical. So Professor Lipson's point is that in this current set of releases, Sullivan and Cromwell would not actually be released for any pre-bankruptcy crime claims that are brought against them by third parties. So I know that's like a lot of words, but basically the third party in this case being any of the creditors. If creditors want to sue Sullivan and Cromwell for their behavior pre-bankruptcy, that is still possible within the bounds of the current releases that are explicitly in the release section of this plan. But there are a whole bunch of caveats here. And the reason I say that this actually is arguably more cynical than what existed before is like, it almost feels like the debtors are trying to make it seem like they're not going to get releases here so that people will go along, vote for this plan. But there are actually all sorts of other ways they may get the releases they want in the end, therefore crushing the current lawsuit being brought against them and any future litigation that might be brought against them. So there are two things I want to highlight here. First of all, what Professor Lipson says is they can easily basically sneak these releases in later on. So they could add additional releases for themselves into what is called a plan supplement, which they would put forth shortly before a plan confirmation hearing in front of the judge. But creditors wouldn't get to vote on that plan supplement specifically, so they'd sort of be circumventing the creditors in that case. There's also the Supreme Court has actually recently heard arguments in the Purdue Pharma bankruptcy case around the legality of third-party releases. Basically, does a debtor entity, does FTX, the debtor entity, even have the ability, have the legal right to give people, give entities, give Sullivan and Cromwell in this case, a release on behalf of creditors? Right? It's a little bit strange just as a concept that the debtors can say, hey, we're going to release you from any crimes or any claims that creditors might have against you. It feels like an overreach. And the Supreme Court has already heard arguments about this, and we'll see what happens. I'm not necessarily optimistic that third-party releases are going to be thrown out of the legal system based on the arguments of the Supreme Court, but there's a chance. So Professor Lipson has said, there's also a good chance that Sullivan and Cromwell have not included these releases in this current version of the plan because they are waiting to just see what happens with the Supreme Court before they even deal with the issue. But here's the second thing. And this also has come from Mr. Purple, who talked about this on Twitter. This bankruptcy plan has something called a anti-double dip provision. And my reading is that this is about making sure that creditors, customers don't game the system by actually getting paid out, getting their claim paid out twice. For example, there's potentially a way to have your claim go through the Bahamian bankruptcy system versus the US system. I might be butchering the specifics here, but you could try and get paid out on your claim both places. So this provision is in place to make sure that nobody gets paid out for their claim twice. That seems like a reasonably normal thing to try and prevent and to have in this bankruptcy plan. But there is something that appears to be very atypical about this. So what Mr. Purple writes here is, this provision includes mostly standard language with one glaring addition. The debtors would force claimants to effectively waive recoveries from any class action lawsuits, including the one against Sullivan and Cromwell. This is a wholly unacceptable and inappropriate form of release against Sullivan and Cromwell for any pre-petition liability without expressly granting them one via this backdoor language addition. It also grants the plan administrator authority to frustrate the recoveries of any plaintiffs in those lawsuits, given the broad authority to withhold distributions, et cetera, et cetera. So basically, in this provision that is supposed to be about making sure that folks aren't double paid out, it has language that would basically say we could refuse to pay out a claim to anybody who maybe got recoveries via a separate lawsuit that they have brought. So if the the creditor's lawsuit is successful against Sullivan and Cromwell, for example, and they were paid out, they were therefore owed recoveries as a result of winning this lawsuit, the payouts that they are then additionally separately owed as part of this bankruptcy could be withheld from them because they've been paid out as a result of this lawsuit. That is my understanding of what this weird language in this double dip provision is saying. And certainly I have spoken with experts on this who are like, I've never seen this before. Like, this is very weird to have this language. So although the language in the release section of the bankruptcy plan is no longer as broad and sweeping as it was in an earlier draft of the plan, that really isn't gaining creditors anything, because the same kind of exculpations and releases are likely going to be achieved in other ways. And that is our show for today, folks. I appreciate you sticking with me as we get into the dirty details of things that are happening with this bankruptcy. I will not tell you yet again why I think it's important and why it matters, but I really appreciate you watching and sharing this content, liking the video, subscribing to the channel, all of those things to support this kind of work. It is time consuming and it does not always make for the sexiest content, but I think it is really important. And so I appreciate you being here. And with that, I'll see you next time.